The H-1B visa is one of the most sought-after pathways for foreign professionals to work legally in the United States. Each year, only 85,000 visas are available, making this status both valuable and competitive for skilled workers around the world. H-1B status allows foreign nationals to work temporarily in the United States in specialty occupations for up to 6 years. This non-immigrant visa is designed for positions requiring theoretical and practical application of specialized knowledge, typically requiring at least a bachelor's degree or equivalent experience. Of the 85,000 annual visas, 20,000 are reserved specifically for individuals with advanced degrees from accredited U.S. institutions. This allocation reflects the program's emphasis on attracting highly educated talent to the American workforce. One of the most significant advantages of H-1B status is the concept of dual intent. Unlike many other non-immigrant visas, H-1B holders can legally pursue permanent residency while maintaining their temporary status. This provides a clear pathway to potentially settling in the United States long-term. H-1B status also offers considerable flexibility. Visa holders can travel freely both domestically and internationally without additional documentation, provided they remain within their visa's valid dates. They can purchase property, invest in stocks and other assets, take various types of leave, and enjoy many of the same financial freedoms as permanent residents. The cost of obtaining an H-1B visa varies based on employer size. For companies with 1 to 25 full-time employees, the total fees range from approximately $1,500 to $2,500. Larger employers with 26 or more workers face higher fees, typically between $2,300 and $3,300. These costs are legally required to be paid by the employer, not the visa applicant. To qualify for H-1B status, applicants must meet several key requirements. First, they need at least a bachelor's degree or equivalent experience in their specialty field. Second, they must have a job offer from a U.S. employer willing to sponsor their petition. Third, the employer must obtain an approved labor condition application from the Department of Labor, confirming that hiring the foreign worker won't adversely affect U.S. workers' wages or conditions. Since 2020, the application process has been streamlined through an electronic registration system. Employers must first register each potential H-1B worker during a designated period, paying a $10 fee per beneficiary. If registrations exceed the annual cap, USCIS conducts a random lottery selection. Only those selected through this process may proceed with filing the complete H-1B petition. After applying, tracking your visa status is straightforward through several methods. The primary approach is using the USCIS Case Status Online system. You'll need your 13-digit receipt number, which begins with letters indicating which service center is processing your application. The system provides real-time updates on your case progress. For those without internet access, status checks are also available via phone or email through the appropriate service center. The automated systems provide information on filing dates and estimated processing timeframes. H-1B processing times vary significantly depending on several factors. Standard processing typically takes 3 to 6 months, while premium processing guarantees a decision within 15 days for an additional fee of $2,500. If USCIS requests additional evidence, expect further delays of several weeks. While H-1B status is initially granted for 3 years, extensions are possible. The standard maximum stay is 6 years, but extensions beyond this limit are available under specific circumstances. If you have an approved employment-based immigrant petition or if your green card process has been pending for more than 365 days, you may qualify for extensions in 1-year or 3-year increments. Material changes to employment conditions require filing an H-1B amendment. This includes significant job role modifications, workplace relocations outside the original metropolitan area, or corporate restructuring that affects job responsibilities. Importantly, H-1B holders can also transfer to new employers through a process that allows them to begin working as soon as the new petition is received by USCIS. Family members of H-1B workers can join them in the United States under H-4 dependent status. While H-4 visa holders traditionally couldn't work, certain spouses may now qualify for employment authorization if the principal H-1B holder has an approved immigrant petition. It's important to understand that H-1B status is tied to employer sponsorship. Self-employment is not permitted, and visa holders cannot work as independent contractors. However, working for multiple employers is possible if each files a separate H-1B petition. If your H-1B visa expires while an extension is pending, you may continue working for up to 240 days beyond the expiration date, provided the extension was filed before the original visa expired. The H-1B program continues to evolve with policy changes and legal updates. Staying informed about current requirements and procedures is essential for both employers and visa holders to maintain compliance and maximize the benefits of this valuable immigration status. Navigating the complexities of H-1B status requires attention to detail and understanding of immigration regulations. With proper planning and awareness of the requirements, foreign professionals can successfully establish their careers in the United States while potentially building a path to permanent residency.